Amendment Act is to modify the decision given by this court. Indrolom Kavduyevkov Avuchi, On of India, 1970, 3 SCR 530, where it washled by 10 jugos that the balling companies, acquisition and transfer of umber, 10 Supreme Court reports 1973 subscar undertakings. Act violated the guarantee of compensation under Article 3.2, in that it provided for giving certain amounts determined according to principles, which were not relevant in the determination of compensation of the undertaking, of the named banks, and by the method prescribed the amount so declared could not be regarded as compensation. Since the word compensation has been deliberately omitted and substituted by the word amount in the amended Article 31.2, it is not possible to give to the word amount the figurative meaning, that is, the full value. Article 3.2 postulates that in some cases principles may be laid down for determining the amount, and these principles may lead to an adequate amount or an inadequate amount. So this shows that the word amount here means something to be given in lieu of the property to be acquired. But this amount has to and can be worked out by laying down certain principles. The principles must then have a reasonable relationship to the property which is sought to be acquired. If this is so, amount, ultimately, arrived at by applying the principles must have some reasonable relationship with the property to be acquired. Otherwise, the principles laid down by the Act could hardly be principles within the meaning of Article 31.2. Similarly, when the amount is fixed by law, the amount so fixed must also be fixed in accordance with some principles, because it could not have been intended that, if the amount is fixed by law, the legislature would fix the amount arbitrarily. When the government places the legislation fixing the amount before the legislature, it will have to show that it has been fixed according to some principles. These principles cannot be different from the principle which the legislature would lay down. The change effected by the amendment in Article 31.2 is that a person whose property is acquired can no longer claim full compensation or just compensation, but he can still claim that the law should lay down principles to determine the amount which he is to get, and these principles must have a rational relation to the property sought to be acquired. Article 31.2 were to be interpreted as meaning that even an arbitrary or illusory or a grossly low amount could be given, which would shock not only the judicial conscience but the conscience of every reasonable human being. A right to property under Article 31 consists of three things. First, the property shall be acquired by or under a valid laws only. It shall be acquired only for a public purpose. And thirdly, a person whose property has been acquired shall he given an amount in lieu thereof which is nor arbitrary, illusory, or shocking to the judicial conscience or to the conscience of mankind. Parliament has no power under the Article 368 to abrogate the fundamental rights, but can amend or re-regulate or adjust them in its exercise of amending power without destroying them. Applying this to the fundamental right of property, Parliament cannot CN1 power legislatures to fix an arbitrary amount or illusory amount or an amount that virtually amounts to confiscation, taking all the relevant circumstances of the acquisition into consideration. Same considerations apply to the manner of payment. It cannot be interpreted to mean that an arbitrary manner of payment is contemplated. If discretion is conferred, it must be exercised reasonably. Pond 95, 196, 197, Roberts v. Hopewood, 1925, AC 578590, and Fames Lasley Williams v. Haynes, Thomas, 1911, AC 381, referred to. Article 31, 2b, the effect of which is to make Article L9F inapplicable, cannot be said to be an unrealisable abridgment of right under Article 19.1. While passing a law fixing principles, the legislatures are bound to provide a procedure for the determination of the amount, and if the procedure is arbitrary, that provision may well be struck down under Article 14 P999, Kesavananda v. Kelala, Sikri, CJ, 11 Sec. 3, of the Constitution 25th Amendment Act, 1971. Isvio, IJ as it delegates power to legislatures to amend the Constitution, Article 368 DOI, has not enabled Parliament in its constituent capacity to delegate function of amending the Constitution onto another legislature or to itself. In its ordinary legislative capacity, the expression, notwithstanding anything contained in Article 13 with which Article 31c open canum t mean that not only fundamental rights like Article